Final case on the docket is ROLLAS versus Voigt.
Good morning, Your Honors. May it please the Court. My name is Bob Case. I represent the appellant, John ROLLAS. I would like to reserve 5 minutes of my time. Okay. Your Honors, we're here today to correct an error by the Florida Real Estate Commission in denying Mr. ROLLAS's claim under the Recovery Fund. Now, the error is first shown by the transcript. In that transcript, you can see that the Commission focuses on a loan relationship as a debtor-creditor, and then second, they focus on a membership interest as an LLC agreement. That focus goes from the transcript into their final order. In the final order, they focus on the loan and in the LLC again. They make two findings of fact. The first finding of fact was that the licensee was not acting solely in his capacity, and then they parenthetically reference an LLC agreement, which transferred a 20% membership interest to Mr. ROLLAS in an LLC. Now, that limited liability company is Priority One Management, and what happened is Mr. ROLLAS had given a loan, and in exchange or for collateral, he took a 20% membership interest. Why? So that he could look at the finances and make sure that the money is being used appropriately. The second finding of fact was that Mr. Voigt, the licensee, and Mr. ROLLAS had a membership or a partnership agreement. That finding of facts, or those two findings of fact, become their conclusion of law that there was not a sufficient meeting of the elements. And they focus on Section 475.482(1)(c), saying that the licensee didn't act solely in his capacity as a licensee in the transaction. That's the 1C exclusion. The second one is they said, well, under 475.482(1)(b), these guys were in a partnership. They said that specifically that Mr. ROLLAS had entered into a partnership agreement. They completely forget about the other portion of 1B that says, and that partnership was a buyer, a seller, a landlord, or a tenant in the transaction. So the question is, what's the transaction? We argued that it is the property management, that the licensee had agreed that he would manage Mr. ROLLAS's residential properties, his investment properties. And that property management is what arose this claim. That's the definition of transaction. Now, it's not defined in the statute. It's never been defined in the statute. The 5th District is very familiar with this statute, and back in 1988, it started doing the analysis of what does transaction mean. In Riggs versus the DBPR, this court said it's a series of events without any specific beginning or ending, where you are supposed to look at the acts of the licensee, not a relationship. Then in 1995, this court looked at it in Gauthier versus the Florida Real Estate Commission, and again said, what are the activities which gave rise to the claim? And this court talked about the Riggs decision and said, again, look at the licensee's acts, not the relationship. And then most recently in 2016, this court in Hendricks versus the DBPR again said, what were the activities of the licensee which are unrelated to his broker capacity? Now, contrary to looking at the activities, and we say those activities are when Mr. Voigt, the licensee, received rent from tenants, received security deposits from tenants, then commingled those funds. He took those funds and he used it for his own purposes. He didn't pay anything to Mr. ROLLAS. And that's what gave the claim. There was even a final judgment that was entered that said, this is what caused Mr. ROLLAS's damage. That was the basis for the claim under the fund. Contrary to that, the commission and the department's attorneys focused on relationship. Relationship is not a disqualifier. If your honors looked at the
The
transcript,
statute has a $50,000 limit,
it does.
and the judgment recites in the civil case that the security deposits that were converted and the rental proceeds that were converted were in excess of $50,000.
The total judgment is in excess of $206,000.
As far as the rental proceeds and the security deposits, those exceeded $50,000 on their own.
Yes.
And that's the basis of your claim against the recovery fund, is just on the security deposits and the rental proceeds that were converted by Mr. Voigt.
Effectively, there was also money that had to be paid by Mr. Rollas to be able to reimburse vendors who the property management company, who the licensee had hired to do work but then didn't pay. Of the $206,000 judgment, only $37,500 of that is the loan. So when you're looking at the relationship of what arose this claim, it is absolutely not the loan, it's the property management. Now, what the department did in the analysis, and this is Mr. Kendrick on page 16 of the transcript, he said, "I believe the letter of the law is pretty clear. This really is a joint venture, end of story." He said, "The moment they signed that LLC agreement and Mr. Rollas got the 20% share, to me, that's the end of it." So he wasn't looking any further than the LLC agreement. He wasn't paying any attention to 475.482(1)B, which says the LLC also must be a buyer, seller, landlord, or tenant in the transaction. Now, this problem continued because on page 21 of the transcript, Commissioner Hornsleth does the same focus. He says, to him, Mr. Rollas became a 20% owner because he had become a lender and loaned the licensee some money, and in the hopes of getting the money back, he'd be a partner in the business. He said, "It seems like Mr. Rollas caused a lot of the mess himself by not seeking legal advice on the loan and then becoming a shareholder." Again, the focus is not on the acts. The focus is on the relationship, the fact that they were in a partnership. But nobody ever said from the commissioner or the department, and there is substantial competent evidence that the LLC was a buyer, seller, landlord, or tenant. This becomes a problem because now what is happening is the department is misquoting or applying new statutes. If you look at 475.251B, that statute says 25, section or subsection 25 says, here's what the violations are. 1B was cited by the department as excluding this from being able to cause a claim because of the LLC membership. In fact, though, 475.251B says it's irrelevant. Actually, they use the word immaterial to the guilt of the licensee to be in a confidential relationship. That statute actually says it doesn't matter if you're in a confidential relationship, such as members of an LLC, or if you're a general member of the identified public. You're still going to be guilty. The only thing that matters is, are you also an owner of the company? Now, what the department then says is, well, this has to be a disqualification. Relationship is not a disqualification under these statutes. There's only one section of the statute that uses relationship to disqualify. That's 475.483, subsection 2. There, in subsection 2, the legislature lists what's the relationship that will disqualify you. Remember, subsection 1 says you're eligible if you meet this criteria. There's no question, no argument that Mr. Rollas met the 483 subsection 1 requirements. 483 subsection 2 says, but you're disqualified relationally if you're a spouse, if the licensee is your spouse, if you're the personal representative of the spouse, or if you're the broker himself. That's the only three exclusions for relationship. Now, that specific section goes on to talk about three different additional. Licensee had to be licensed. You have to have the judgment against the licensee. The licensee can't be the owner. But that's not relational. So what the department is doing and what the commission has done by this order is they've added disqualifiers that are not found within the statute. And that's absolutely inappropriate. When you look at this, under 475-42, either 1B, either the buyer, seller, landlord, or tenant, or under 475-42-1C is the act of the licensee unrelated to his broker capacities. They never talk about that. Commissioner Fryer had a problem with this, and he said, I'm having some problems with this because Coldwell Banker is a publicly traded company. Now, Coldwell Banker's not involved. This was an analogy by him. He said, what if I own stock in Coldwell Banker and they were managing my properties, and one of them defrauds me and steals money from me? Because I own stock, I can't file a claim? Commissioner Fryer says, I'm having trouble with that, but that's a legal argument. I'm having trouble making that stretch. So he's relying upon the department's attorneys. Mr. Kendrick on page 23 says, let's look at it another way. This wasn't investigated as a complaint, but I think we would have difficulty bringing an action against the licensee because it's exempt under 475.011 subsection 2, because that exempts joint ventures and partnerships from the chapter. And he said, from this part. Now, here's the only time they talk about the acts. Mr. Kendrick says, so again, it's not that the acts themselves are not violations. It's the becoming that part owner of a brokerage and binding himself to it with his capital share. To me, it precludes recovery. That is an absolute misapplied or misquoted use of 475.011 subsection 2. That is an exemption statute, but what it says is you are exempt if it's your own property, either you individually or you as a company, that you are selling, exchanging, or leasing. Again, no substantial competent evidence that the company that was involved is selling, exchanging, or leasing any of the properties which were managed by the licensee and which were actually owned by Mr. ROLLAS. So then they want to argue that this compensation agreement, that there's been a reduction in the amount that is owed or being paid to Mr. Voigt as the licensee. And what they want to do is they want to say, well, under certain circumstances, he agreed that he would do this property management for 50% or for free, and so that colors all of their dealing. That doesn't change anything. Your Honors, compensation does not affect obligation. And I put that in the reply brief. In that brief, I said, if I owe you money and I'm a general contractor and you and I negotiate to build your house for a less cost because of that expense, just because I've agreed to do it less doesn't mean I can't safely build, I don't need to safely build your home. It doesn't mean that I can turn my back on my responsibilities. I still have those same obligations to you. The same thing as it relates to being a real estate licensee. If I owe you money and you come to me and you say, I want you to sell my house for less commission, and I agree, that doesn't change my obligations to you to handle that money properly, to handle that transaction properly. So what they're saying is that because there was a reduced compensation agreement, that somehow the compensation affected Mr. Voigt's obligation, that Mr. ROLLAS unwittingly, unknowingly negotiated away his right to require Mr. Voigt to comply with his obligations as a licensee. And that somehow, some way, Mr. ROLLAS said, well, because of this, I'm no longer going to have to rely upon the ability to pursue recovery from the fund in the event I'm dealing with an unscrupulous licensee. And that is precisely what happened here. Your Honor, Commissioner Fryer on page 27, he said to Mr. Kendrick, you're citing 475.011 subsection 2. That deals with license exemptions. Can you explain to me how that ties into the other sections of the statute in the recovery fund? Mr. Kendrick says, well, it's exemptions from this part, not just from licensure. And Commissioner Fryer says, okay, so. Mr. Kendrick's response was, let me give you an example. If I have a licensee or a victim that comes and says, I paid this licensee $20,000, and I go and investigate and find out that the licensee says, yeah, I got the $20,000, but I was going to put some of my own money into it, and we were going to buy investment property together. In that case, we couldn't have a claim because the only way we would is under 475.251B, which allows for a charge for any business transaction, and it cuts away having to act as a licensee. 475.251B doesn't say that.
You're approaching 5 minutes. If you wish to reserve, if you want to keep going, it's up to you. It's your time.
I do, Your Honor. I'm actually wrapping up, and I thank you. But because
Whatever you want,
475.20, I'm sorry, Your Honor. I didn't hear what you said.
Pardon?
I thought you said something.
No, I'm just saying, if you want to reserve your time, it's 5 minutes, so you wanted to reserve 5 minutes. So
Okay.
keep going if you want. It's up
No, I'll wrap up and I'll sit down. Let me just tell you that once Mr. Kendrick used that analogy for which there was no evidence in the record, Commissioner Fryer said, thank you, that helps, and he became the second for the chairman's motion to deny this relief. So I'll reserve the
Okay, you'll
rest of
have
the time.
about 5 minutes and 39 seconds left.
Thank you, Judge.
All right.
Good morning, Your Honors, and may it please the Court. My name is Dwight Slater, and I represent the Department of Business and Professional Regulation, Division of Real Estate.
Mr. Slater, I want to try to get us to focus on exactly what's at issue here. It seemed to me that FREC denied the claim for failure to comply or meet the qualifications under 475.4821 subsections B and C.
Yes,
As seemed in your answer brief, you relied exclusively on C.
that's true, Your Honor.
All right, I think it'd be appropriate. Are you conceding that B was not a basis for disqualification?
I would concede that point, Your Honor. It's certainly at least not our strongest argument, for sure.
Well, you didn't make it at all in your brief.
Fair enough, yeah.
Okay. So the whole issue in this case is whether or not the claimant met the requirement in 475.4821C.
Yes.
Okay.
So, and that is the crux of our argument, Your Honor. And this all comes down to one word, and that's the word solely. To recover under the fund, the statute has three threshold criteria, and one of them is that the broker was acting solely in that capacity as a licensee. And it's the division's position, and that's what FREC found, was that he was not indeed acting solely in the capacity of a licensee. He was also acting as a loan debtor. And that
So Mr. Rollas loans X number of dollars to Mr. Voigt. If Mr. Rollas did not take a 20% interest in Mr. Voigt's company, would your position today still be the same?
if the 20% portion was not there, that isn't.
It's an unsecured loan. He's a nice guy. I'm loaning money, and
Well, I think it would also depend on the terms of repayment. Because in this case, even if you take out the 20% interest, part of the repayment was providing management services. So in this instance, the actual broker activity was integral to the loan. It was one of the terms of the loan. The claimant says, I'll loan you this money, you pay me back at this rate, and you throw in 50% discount on your brokerage services. Later, that's renegotiated to you give me your brokerage services for free. So in all of these transactions, not a single one is the broker acting solely in the capacity as a broker. He's acting as a loan debtor. And that's the problem that FREC had with this.
Is that a reduced fee or free if the broker is collecting the rental proceeds and the security deposits from Mr. Rollas' property? Doesn't he have the same ethical obligation not to steal those monies regardless of whether he's charging full freight for his property management or half freight or one-third freight or no freight?
No, he absolutely would. I think the only distinction here is whether he can recover under the fund. And the fund is clear. You have to be acting solely in the capacity as a broker. If there's another portion of that relationship that's not unrelated to brokerage activities, such as seeking a loan.
If the claim is exclusively for money that was converted, if you would, by Mr. Voigt on rental proceeds and security deposits, you'd agree that that's, acting as a property management would be part of his real estate license.
Yes, sir.
And if that's the only claim where his actions embezzling the money, when doing so, was he acting solely in the capacity of a property manager?
The focus is on the transaction. So, and in this case, the transaction is the brokerage activities, but the brokerage activities themselves are a part of a bigger transaction in which there is a different relationship. And I think counsel brought up the Riggs case, and in that case, this court did take a broader view of what the transaction would entail. In that case, the department took a much more narrow view, which is the one I think counsel is proposing, that you look only at the particular brokerage subset of the relationship. But this court said in that case, no, you look at it broader. It wasn't just that portion of the transaction where the broker was acting on his own behalf. It's the whole thing. So he started out this relationship acting as a broker, and it morphed into this other thing. So
in this case, if there was no loan, and for whatever reason Mr. Voigt was not charging Mr. Rollas a fee for his services, just collecting the money on Mr. Rollas's, the rent, et cetera, and then Mr. Voigt stole that money, the fact that there was no fee, I mean, this would be a recoverable event, right?
if I'm understanding the court's question correctly, yes. If this was strictly a broker-client relationship, then this would
We've known each other for 40 years, and you're going to manage my rental properties for free and collect my money and send it to me, and Mr. Voigt said, that's great, I'm willing to do that.
Yes.
And then Mr. Voigt keeps all the money. That would be covered.
That would be covered.
So it's irrelevant about what the compensation rate is, kind of following up what Judge Evander was saying. In my hypothetical, you're saying it becomes different because Mr. Voigt received a loan from Mr. Rollas and had to pay that loan back and was going to use some of the money from these rental proceeds or from whatever to pay that back, per agreement.
It becomes different when the broker is not acting solely in the broker capacity. And I think in this case, it's clear that he wasn't. I mean, he approached him not in a broker capacity. He didn't say, hey, let me manage your properties. He said, I need money for my business. Will you give me some? And the claimant said, sure, I'll give you some, but I want to keep track of things, so give me 20% of this company, of your brokerage company. And they agreed. And a part of that deal, he tossed in the management services. So that wasn't the driving force of the relationship. The driving force of their relationship was a loan debtor and dettee, I suppose.
In our Hendricks case, we said that the statute is to be liberally construed in favor of the claimant, and that's the purpose of the fund, is to reimburse people who are the victims of unscrupulous actions by real estate brokers. Now, there's no doubt we have unscrupulous acts by a real estate broker.
Yes, sir.
Is Freck's position here in accordance with the, liberally construing the statute in favor of the claimant?
Well, it's construing it by its terms. If the court is going to give any effect to the language acting solely within the capacity of a broker, then I think it has to take the department's position. I don't see any other way to read that. To take counsel's position would be to completely ignore that part of the statute.
Well, but in this case, the losses that they claim were the result of actions taken by Mr. Voigt in his capacity as a real estate licensee, as a property manager. But he had a different relationship as well with the claimant. And so, we have losses coming from his actions as a real estate licensee, but we also have a separate relationship. So as far as interpreting the statute, arguably the statute could go either way on that, and then we're supposed to go at the...
Except I would quibble with you on one point. I don't know that the two things are as separate as they may seem, or as the court is suggesting. The brokerage services were an integral part of that loan relationship. It was consideration for the loan. You give me this money and I'll give you back property management services. That relationship can't be separated. So any property management services he provided was payment.
If Mr. Voigt had paid back all the money he was owed and was still acting as property manager and converted these funds, would the claimant's claim be valid?
That's an interesting hypothetical, if you allow me a moment to consider it. Perhaps, but my gut wants to say no, only because that the impetus for the relationship was that the broker wasn't acting solely in that capacity. He was acting as a business owner seeking financing for his agreement, for his services. Excuse me, for his
So
company.
after the judgment's entered, let's say Mr. Voigt's father gives him a check for $37,500 to pay to Mr. Rollas to say, you know, you need to square up your debts. However you run your business is up to you, but you owe that guy, Mr. Rollas, this money. You're not going to besmirch our family name. You need to pay this guy and square that up. And he does. And Mr. Rollas partially satisfies that judgment, referencing the loan debt has now been satisfied, but he still makes a claim to Freck saying, okay, he stole another $170,000 of my money. He was a real estate broker under the statute. I need to at least get 50 back. That's why you guys are there. Wouldn't that be a covered event now?
Okay. Judge Lambert, I think she just clarified Judge Vander's question for me, so I want to
Vague a lot of times.
I'd like to amend my response to you, Judge Vander. I think in that situation it would be if that loan, that debtor-debtee relationship has been satisfied and that part is over, and all that remains is are these services, then potentially, yeah, it would be recoverable. But see, I think here, every time he accepted a deposit or leased an apartment or a building, he was acting in furtherance of that loan. That was consideration. That was a bargain for exchange. That was part of the agreement. So anytime he provided property management services, it was as a loan debtor, even as well as acting as a broker. Because under that agreement, again, he promised to provide these services in exchange for the money. So he got the money, he had to provide the services. So every time he did it, that was a part of that agreement. So it's the intertwined part of the relationship that's a problem for Freck. And I do want to bring up, Council raised the construction fund analog here, and I think that's actually instructive because under that statute, he's actually incorrect in his analogy because the homeowner wouldn't be able to recover in that situation because the recovery fund under the construction statute actually says if you have a separate business relationship outside of the contract, you're not eligible. So under the hypo that he gave, it wouldn't actually work there either. And I think the analog in this statute is the portion that says if the broker is not acting solely in that capacity. It's the same sort of thing. So under the construction side, if the if the contractor is both a contractor and has a separate business relationship with the homeowner, then they're not able to recover under 489. And the same thing is
So in
true.
this case, the $60,000 is loaned, takes no percentage interest in the company, and it's simply a balloon note or it's payable back over a course of 10 years with monthly payments, and it doesn't have any verbiage or language in the note that says it's related to monies collected. The fact that they have a separate loan arrangement, even if the loan proceeds were used in the business by Mr. Voigt, that would be covered by Freck. Is that right?
I think so, because I think part of it is that it was so intertwined. It says, in consideration for this loan, I'm going to give you services at 50%, or I'm going to give you services for free. I know it sounds technical, but I think that is the application of the statute. It says acting solely in that capacity in the transaction, and here, he's borrowing
Following
money.
up what you're saying, so let's say it's okay, we're going to have a separate note, but I'm going to give you services at 50% rate instead of 100% rate, but the note doesn't talk about you're going to pay me out of the the real estate, the rental proceeds. It's just I'm going to pay you back $500 a month, whether my mother gives me the money or however I pay it back. Would that still be covered? I mean, I thought we talked earlier that the fact that the compensation rate might be lower is not really a factor in and of itself.
May I adjust your hypo slightly, Your Honor?
Depends on how you do it.
Fair enough. Say, in my version, say the property management agreement was negotiated first. I'm going to manage your properties for X number of dollars per month, or I'll get a percentage for each unit I lease. That's done. Then later, there's a loan relationship between the two. I don't think there would be a problem with the recovery fund. So perhaps it's with the order in which these happen, or the fact that they happen at the same time, or if it was reversed, I think that potentially could be a problem, but in my hypo, I don't know that it would be.
I thought your significance was that some of the loan was being paid back from some of the proceeds that's being recovered from the rental units.
Actually, I think that's not quite my point. I think my point was more specifically that the act of providing the property management services is an in-kind payment under the loan. because he says, I'm going to provide these services for free if you give me this money. It's a bargain for exchange. So it's not so much the rate or the amount of money, it's the way the services were used under the agreement between the two. So in that case, I don't think you're able to separate the broker from the borrower in this instance.
So if he loaned him $60,000, it says, pay me back $500 per month, whether it's from whatever source, it doesn't matter, but part of our deal is you're going to give me reduced rate or free services for your real estate services and leasing of my property. That now intertwines it too much so that it's not covered by FREC?
I would think so. But I think part of the distinction here, too, is that it started out as a relationship, as a loan, as a borrower-lender relationship, and then it morphed into, or the property management services were added on subsequently, or maybe simultaneously.
But regardless of the loan situation, Mr. Voigt had the exact same duty as a property manager, regardless of whether he had this other relationship or not, as far as how he would manage the properties and, collect the rents and security deposits and account for them, et cetera.
Right, and
So that duty of his, that duty that he breached, was unchanged regardless of whether there was a separate relationship between Mr. Voigt and Mr. Rollas.
yes, Your Honor. In the same way that a contractor's duty wouldn't be changed if he had a separate agreement with a homeowner, but he still wouldn't be able to recover under the recovery fund because there's a separate business relationship, and the statute's very clear on that. And here I think the statute is clear as well, that if the broker is acting in some capacity other than as a broker, then the claimant is unable to recover. And I think you raise a good point. The duty that the broker owes to Mr. Rollas doesn't change, and that's why the department can still discipline him. And the statute that counsel quoted was actually a disciplinary statute. The specific provision escapes me at this exact moment, but the one where it says it's immaterial, the confidential relationship between the licensee and the would-be victim. That's actually under the disciplinary statute, or disciplinary portion of the statute. So in that instance, the relationship between the two doesn't matter. We can still discipline the licensee, which is in fact what we did here. We revoked Mr. Voigt's license. So again, it's not so much the relation. It is exactly that. It's the relationship. It's the role that the licensee played in this transaction, which was it solely as a broker. The department's position in FREC found that it was not, and the record supports that conclusion. And I think some of this court's cases actually support the department's position more than they do my friend on the other side. And if the court takes the broader view, as I mentioned earlier, that this isn't just looking at one part of the transaction, which is actually what counsel is suggesting the court do, only look at this portion. But in the Riggs case, the court looked at the broader picture and looked at all the dealings between the parties. And actually in the Hendricks case as well, looked at all the different activities unrelated to the broker activities that the licensee took. And here there are numerous actions that the licensee took. He approached him for money. He borrowed money. All of these and he had other relationships outside of just the property management relationship. And that's the problem I think the statute tries to prevent recovery under. And I don't think this is at all an unusual reading of the statute. It says acting solely in the capacity of a broker. I mean, there are numerous reasons why I think that would be something the legislature would advocate or actually enact. Because in a situation exactly like this, we're trying to figure out exactly, so you own 20% of this guy's company, but you're saying his company is robbing you. Does that mean your company is robbing you? It sort of confuses things. And
So if you own 1%, would that have any significance to you?
I don't think it matters. He owns the company. He's a partner in it. So I think that absolutely has significance. It certainly has significance to FREC, and it seems to me that it has significance to the legislature because they put those words in there. I see I'm running short on time.
Yeah, you've got about 1 minute and 40 seconds left.
Let's see. Okay, so just briefly, I'd like to return to the Riggs case because I think this was the first time this court construed the statute. Although I will say that the statute has changed since then, actually, maybe even a couple of times. But at the time, the important thing that the court looked at, because in that case, the department denied the claim because the department's position was the licensee was acting as the seller or the buyer, whichever, in that transaction. But the court took a look and said, actually, no, this started out as a broker-client relationship. The would-be buyer of the lot came to the broker and said, I'd like to buy these lots of land that you've listed. And the broker said, sure. But then the buyer couldn't get financing, so the broker stepped in, borrowed money with the would-be buyer's earnest money, and then kind of took over the whole situation and re-engineered it in a way where he was the one who was going to make a profit. So the court looked at that and said, we're not going to look solely at the part where he sold the property back to the buyer. We're going to look at the entire relationship. And it started as a broker-client relationship and ended up with the licensee jumping into the middle, inserting himself, and front-running is the industry term. So I think here, if you look at the entire relationship, it's not strictly the broker-client relationship. It's debtor-lender relationship as well. And that's why FRAC denied it. That's supported by competent substantial evidence in the record, and it's the division's position that this court should affirm. Thank you.
Okay, thank you very much. We got about 4.5 minutes.
Thank you, Your Honor. First, they were talking about whether it's solely acting under 1C in his capacity as a licensee. So what acts have they described which were not acting as a licensee? They want to look at Riggs. Well, I agree, look at Riggs, because in that case, the licensee was a lender as well. And this court didn't hold that against him. There's nothing in the statute, there's nothing in this court's opinions that say you cannot have any other interaction, any other relationship. It's just what were the acts which give rise to the claim. So in Riggs, this court said, the licensee, you're a lender, that's not going to bar you. Commission, be careful in how you interpret transaction so as to not narrowly construe this and to limit access to the statute. In 1995, this court in Gauthier versus Freck dealt with somebody who was also a co-obligor. The licensee was a co-obligor on a promissory note. Actually, it was an agreement to purchase some property. And this court again said, well, that's not the issue. The problem with that situation was the breach of contract was the foundation for the claim. The breach of contract was the foundation for the final judgment. And this court said, there's nothing that has been alleged that shows it was an act of the licensee. In other words, a violation of 475.25 of Florida statutes. Now that's the section that talks about what kind of discipline can be done. But it also, in 475.482, says the final judgment must say it's a violation of that .25 provision. This final judgment does. So both in Riggs and in Gauthier, there were other relationships, and the court looked at that and said, well, is that the basis for the claim? What the department is not paying attention to is 475.43. That creates a presumption that a person who is, in this case, leasing the property for someone else, if they're not the title owner, is acting as a broker. And in that case, or in that statute, it puts the burden on the licensee to say, well, no, I was not acting as a broker. I would say the same thing here. If they're saying that Mr. Voigt was not acting as the licensee, 475.43 puts the burden on them to show that the acts which gave rise to Mr. ROLLAS' claims are not broker activities, not the fact that they had some other relationship. Your Honor, you said it right. This is a remedial statute. There's a remedial purpose. Unfortunately, what the department is doing and what the commission is doing, they're narrowing the ability to access the remedial purpose, the relief that's been intended by the legislature, by creating exclusions which are not there, by creating language that is not found in 1C and saying you can't have any other relationship. They used the term the driving force of the relationship. Well, that's really not where the court's focus, or the commission's focus, was supposed to be. It was on the acts, as stated by this court since 1988 in Riggs. If your honors don't have another question for me, I'll go ahead and conclude and just ask that you remand with directions to award $50,000. Your Honor, you asked what the amounts were. There was $26,801 in security deposits. There was $133,932.69 in rent, and there was $1,605 in vendors. So it's well in excess of the $50,000 threshold. Thank you, Judge.
Well argued on both sides.